We're going to go ahead and call the meeting to order. Roll call. Everyone's here that was supposed to be here. Next thing is go through some announcements. This will be the third special meeting that was advertised. This meeting will return to the original format of 3-minute public testimony per individual with a combined testimony limit of 4 speaker time transfers or 12 minutes and 1 available rebuttal time limit of 1.5 minutes. The Planning Commission members still noted there was some public confusion from the previous meeting testimony regarding conditional use permits versus special use permits and incorporated areas versus unincorporated areas of Pennington County. Planning Department staff will take a few moments to clarify these items. This meeting is the last scheduled special meeting of the Planning Commission on the proposed vacation home rental ordinance. This is not to be construed as meaning this is the end of public review and comment available to the Pennington County citizens. The next scheduled meeting of the County Planning Commission will have an agenda item to facilitate discussion and or action on several of the proposed vacation home ordinance items in the current draft that have been directly questioned in the public hearings. These topics and the others which may be included by the commission members will be discussed publicly at the April 10th, 2023 regularly scheduled Planning Commission meeting. Any county citizen may attend this meeting and any future meetings of the Planning Commission to participate in those discussions. Any citizen unable to attend any such meeting may send an email to the Planning Department regarding their comments, concerns for inclusion in the vacation home ordinance agenda discussion. We assure those participating in the ordinance review process, your emails are provided to the planning commissioners with their agenda packets and are considered during the review process. Citizens interested in the review of the vacation home ordinance will want to follow the ordinance draft through the Planning Commission and the Board of Commissioners scheduled meetings by the Pennington County Internet site. The last thing, and I just wrote this on there, I thank all of you for coming, all 3 meetings. Anyone that's not here, I hope they're still following it. And if they are and plan to attend future ones or they can't make it, use that email. But I thank you for attending, and your input has been considered on a lot of the items.
I would like to add to that, Charlie.
Yeah.
The last 2 special meetings, we've heard a lot of testimony about the 1-acre lots. We understand there's a lot of concern about that, and we're not ready to discuss it among ourselves yet. We will do that probably on April 10th. But if there are other items in the ordinance that concern you, please bring them up tonight so we know. Don't assume we're going to read your minds. Please bring those other items up so we understand what your concerns are in total. Thank you.
All right. Next item on the agenda is approval of the agenda. Is it everybody reviewed the last?
Mr. Chair, I move we approve the agenda.
Second.
Is there a second? Moved and seconded to approve the agenda. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Meeting procedure, we went through it, the 3 minutes. We're going to kind of hold to that this time. Everyone understood last time we tried to insert some items and it just didn't work. You get up, say what you would like to testify in regards to the ordinance. If you have special items, I agree with the Commissioner that we need to get them on the table tonight so that they're on that April 10th agenda that will begin the review of this ordinance. We're taking off from there. We've got the ordinance amendment. Does anyone wish to have a copy that it's part of our agenda packet, so we've got it here in front of us if you have your own that you're referring to when you're speaking. And I do have some speaker request forms already that have been submitted. we can sure get you one. We'll get one. We've got it in it's all part of these here, but I don't have an extra, but I'll make sure you get one.
That's a great thing. I've been out of the country the last time I just gotten back, and I just got back last night, so I've not been able to get a copy.
Okay. And there's been a few corrections already made, more procedural corrections or clerical than anything so far. Thank you. Please let me know your name and we'll get it to you. First speaker request is Joyce Segru. Joyce, just introduce yourself for the record and go from there.
My name is Joyce Shagru. I live in Silver City. I've been involved, and I'm going to read this pretty much so I can get through it in 3 minutes. I've been involved since the beginning of planning for a VHR ordinance, representing neighbors and guests. You are hearing mostly from owners and managers, not neighbors and guests. And first of all, I want to make another comment. I read the written comments from the last meeting, and I thought they were excellent. Just as an aside, it is much easier for owners and managers to organize for meetings like this than it is for neighbors and guests. It's virtually impossible to get guests representing themselves here. I want to ask that you recognize them and that group or those groups are taken into consideration. I will speak to the 1 acre requirement and the ordinance in general if I have time. I live in Silver City in the lower level, a multi-generational house. Density has been an issue here. I live very close to a VHR, legal non-conforming, right off the corner, the side of my apartment. Silver City is made up, if you aren't aware of that little community, of a few full-time residences, a few VHRs, which have either CUPs or are legal non-conforming, and many family vacation homes, which are sometimes rented. Prior to the 1 acre requirement, there were many complaints about the number of VHRs close to other cabins or houses. With a 1 acre requirement, those complaints have ceased. Some in the community do not agree with the 1 acre requirement because they say it is stifling business or view it as unfair because the legal non-conforming were allowed to continue and only a couple of CUPs have been permitted. I'm speaking for Silver City now, or in Silver City. There are only a very few who have 1 acre or more size lots in Silver City. Our lots are platted at 25 feet by 100 feet, which is unbuildable, so most of us have several lots put together. I request you retain the 1 acre or be very careful if you make revisions. And then I'll speak to the ordinance in general. It has been a positive as I think about it for Silver City. To my knowledge, there has been only one incident with my VHR neighbor since I moved there 3 years ago. This VHR is well managed and the managers live about a block away. A dangerous situation developed when folks started fighting and it was escalating. You can think that it's probably a little farther than from here to the door from where I live. The managers were called and immediately intervened, which avoided the need to call the sheriff, as I recall. It is an advantage to have good managers. Good managers are important across the whole spectrum. Living close by, who are assertive and quickly can intervene if things
Joyce,
go
can you go
wrong.
ahead and wrap it up then?
Okay. These managers had many complaints prior to the VHR ordinance, rightly or wrongly. They both own and manage VHRs. They comply with the CUP conditions and do not have complaints. In conclusion, the ordinance has made management easier for providers and more safe for guests. The 1 acre requirement has made it better for neighbors. The ordinance in its entirety has helped us get to this point. Thank you. And are there any questions?
Questions for Joyce? Joyce, you've been in a place that actually, some people think that the vacation home rental really started there as far as the hills.
They've been there a long time, yes.
And your lot configuration in Silver City is different than most areas of the county because of the 25 by 140.
It's an
Is
old mining village,
correct,
platted that way for residences, however.
correct. And what you're saying is that if if we were to look at removing the 1 acre, would be not very conducive, but it could be tough on Silver City too.
It would change our environment again and revert to some of the issues we had in the past, I think.
Some of the issues might
Resurface.
okay. That was where I was heading
Yeah,
with it. You
it's
knew.
quiet. It's quiet now, well managed.
Okay. And how many are you aware, just, are there quite a few in the actual downtown area or the site area?
There's one business, and that's Rita and Telly Chapman, and they're here and they
Sure.
can speak to that. And I think they have 5. There's one next to me, which is legal nonconforming, and there may be others. And then quite a few are rented for the 14 days or less in town
Okay.
during the summer season.
Under the so-called rally rule. All right. That answers my question. Thank you. Any other questions for Joyce? Dessel, Peterson.
Hello again. I'll try to be brief. On the 1 acre, if you decide to eliminate that, then I would ask you to take into account what the impact is on neighbors. I think the staff would say that one of the most complaints they get is about trespassing. So if in fact you eliminate the 1 acre minimum, I'd like you to at least to consider that there be some sort of requirement for a physical separation along the property line, whether it's a fence or trees or terrain or whatever, that has to be in place if the house is too close, if the house is closer than 50 feet to the property line. We've had numerous problems with trespassing at the one house that we had in our neighborhood. And something should be done. My neighbor actually put up the fence in order to stop it, and it's unfortunate he had to suffer the expense of doing that. Secondly, on the transfer of licenses, as I recall the discussion at the committee level, it was an owner of a vacation home rental who asked for that termination rather than have it be transferred. And I think she, if I recall correctly, that she encountered some problems because her name was still on the license, and and the problem really was with the new people coming in. So I think it is important to consider that the license not be transferred. And you can acknowledge people like the folks in Silver City, that they have a non-conforming use, that it wouldn't apply to them because this is a rule that has come in after they're in existence. So they wouldn't be subject to that transfer prohibition. Third thing, on parking, I think it's absolutely necessary that the parking be on site and that there be sufficient space for them. We've had situations where there have been multiple vehicles and trailers that have arrived, and they need to have space for all of those with side-by-sides and others. We need to have enough parking. And one of the problems in the county, as you well know, we have quite a diversity in roads, and most of the roads that I'm aware of in the county really don't have space for parking on the road themselves. They're all very narrow. Even major roads like Nemo Road, there's not much room for parking. And finally, I wanted to address the issue of fees. The committee really wanted to increase the amount of fees because we feel that there needs to be more enforcement. And right now, there's only one enforcement officer for the county, and he is charged with enforcing all of the planning ordinances. It's not just the VHR ordinance. And I personally would like to see those fees go towards increased enforcement officers. So those are my comments. Just one, do I have just one more minute or half a minute? Or am I done?
You
I'm
have
done?
time.
I'm done. All I wanted to do was just for the audience, so that they understood the makeup of the committee. The committee was actually no- selected by the board, but it was through a recommendation process from staff. 3 of the members of that committee were people who were owners or managers of VHRs. A 4th one was the owner of a bed and breakfast. A 5th one was to represent Elevate Rapid City. And the last 2 were the ones that represented neighborhood interests. So we were outnumbered on that on that committee. So a lot of this stuff is actually coming from people who are in the business of VHRs. So I think that that's important for you to know that they were in support of a lot of what we have put in front of you. Thank you very much.
Questions for Dessel? Dessel, thank you for introducing that makeup of the committee. I was going to make sure that the audience knew that at this meeting, so thank you for that. And just to review it, she's absolutely correct. For the commission, she broke the membership down, and that was the appointed members from the Board of Commissioners. So and the meetings were well attended as well. I haven't got many request forms, so we may have to do it by hand. Robert Heckel?
Robert Heckel. I'm back again. Nice to see you all. I'm going to read this real quick. It's
Sure.
nothing particular on any specific regulation in there, but my name is Robert Heckel. I am the newly elected president of the Association for the State of South Dakota that is going to be representing short-term rentals. There's a board of 11 of us that have formed, and it's growing at this point. Firstly, I wanted to stress that we are not just representing short-term rental industry. We are here to represent all supporting industries that make up the industry that is possible, such as contractors, handymen, cleaners, bookers, marketers, realtors, investors, and anyone else that has a stake in this rapidly growing segment in our community. We invite you all to pull up a chair to join us. Our objective is to ensure that the short-term rental industry is no longer viewed as a Wild West or tourism, but instead is governed by our own members for its own members and for the benefit of the communities we serve. We want to work in collaboration with state and local government to set reasonable regulations that protect the public and improve industry as a whole. South Dakota has already shown that it's open to new and diverse industries, from piercing, tattoo shops, dispensaries, adult entertainment venues, and other associations to exist in our industry. Moving forward, we will focus our energy on achieving our goal of writing our own ordinance that fits the vision of Planning and Zoning Commission, as well as meeting the needs and expectations of short-term rental industry. We're eager to work with the commissioners and planning and zoning staff to update and finalize the guidelines, process ordinances that affect our industry and the public. We believe that it would be in everyone's best interest to directly work with planning and zoning on this matter to ensure timely resolution of these issues rather than dragging out the process hot topic by hot topic. Tonight, I'm sure you'll hear from another handful of people in the industry. I thank you guys for your time, but I would like, if you would, have Patrick come up next. He's the
Patrick
newly
is up
elected vice
next.
president, so he's got a bunch of stuff to let you guys hear too. So I appreciate your time.
Any questions for Robert? Thank you, Robert. Patrick Ely? Ely.
I might have misunderstood the forum rules. At the last meeting, I thought we could do presentations, maybe special presentations. I prepared a PowerPoint, but if that's not possible, or amend the 3-minute talking rule, or maybe I can go with the last so everyone else has time, or.
The PowerPoint
Yes.
will probably be available during the review of the ordinance. We can, if you'll let the planning staff know
Yeah, I can
in
certainly share.
advance. When we review that, we start our meetings on April 10th on that ordinance. And that will be the planning commission, and it has to go through that process first before it goes to the board of commissioners, at which time you would, if you had a PowerPoint, you've got to review with, they have a separate staff.
Okay, so can I just play?
We
put a
didn't
voice
set
on that?
up,
Okay.
we didn't really set up for it tonight, to be honest.
Okay.
If you feel, I mean, how long is this going to take to get it on?
I need about 10 minutes to go through everything.
I'm not, as far as the meeting, when we begin to get down, this is for, these public meetings were scheduled so folks would have an opportunity to voice their concerns overall on the ordinance or specific items that they see that they want the planning commission to pay attention to in the review process. That review process for that ordinance doesn't start until April 10th.
Okay,
We're
so,
part of it here taking testimony to assist us in that review process.
yes.
Okay. And so we didn't set up for that. No, I'm sorry.
Okay, I don't know if I can condense it into 3 minutes. There's about 10 minutes of material here. So I must have misunderstood the rules from the last meeting. I thought we were invited to bring presentations as featured speakers and talk a little bit longer. Okay.
It's been 3 minutes, all the meetings.
Okay. Can I make a request for the next meeting then and present it properly?
That's what I'm saying. If you'll work with our staff at planning
Okay.
so that we have the right equipment and the right, I know these computer things aren't just plug in and let's push the button and go. You're going to want to have it so that it appears on the screen as you need it to appear. So if you'll work, these are two members, Brittany's the director and Jason's the assistant director.
Okay.
If you get a hold of them through the planning department, we can assist you to have that service available to you during that April 10th meeting, yes.
Okay. All right, April 10th. Thank you.
Okay. Thank you, Patrick. You don't want to just wing it for something to say for now, huh? For your 3 minutes.
I can speed past it, that's not going to do it justice to the message.
Okay, I understand.
It's new material, so.
Thank you. I don't have any other speaker requests. Does anybody else want to speak tonight? No, we're not going to do that. We're not set up to do it, and we didn't advertise to do that. We do that service, Patrick, during our meetings. We've allowed other folks to go ahead and put on their presentations.
I could just read it off the screen, but.
Could I come off?
You have to. Thank you. Go ahead. Introduce yourself for the record, Jordan.
Jordan Hirschfeld, nice to see you guys. I don't have anything to bring up in regards to the ordinance. I do have a question though. So just for clarification, like what authority do you guys have in terms of amending this ordinance? Is there any authority or what are we doing here in terms of the public coming to you with various concerns? What authority do you guys hold in regards to the current ordinance?
Absolutely have authority. We can vote not to even send it forward.
Sure.
So everything from kill it to amend it.
Amending. Okay. That was all I.
Now I'm going to go ahead and, did you have anything else?
No.
Okay. Thank you, Jordan.
Yes, thanks.
Real quick, I can
Yeah,
probably answer.
go ahead.
Megan Kruger with the state's attorney's office. So essentially, the authority that you guys have is to recommend certain things to the Board of Commissioners. The Board of Commissioners is ultimately the body that makes the determination on the final ordinance. So this is a recommending body, and then the Board of Commissioners ultimately decide what is going to be passed. So, for example, this Planning Commission could recommend certain changes that the Board of Commissioners chooses not to adopt. Just so that way that's clear for everybody in the room.
Yes, it's not a sure thing. That's
Yes.
correct.
Yep, it is only a recommendation.
Our amendments are not sure things. Correct. Thank you. I'm going to open what Patrick wants for discussion. What do you want to do on it?
If I understand correctly, you said that up to 4 people can give Patrick their 3 minutes, which would give him a total of 12 minutes.
Sure. That's
So-
another way of looking at it.
That's a way that this could be accomplished within the rules set forth by the opening
Correct.
statement.
Patrick, if 4 people wanted to make sure that you got your dog and pony show on, If there's four of them that'll do it, let's do it. You got it.
Okay.
You're on. You're on, and there is no hook. We'll just let you know when the 12 minutes go by. All right?
Alrighty, I appreciate it, guys. Okay, so I'll just share the slides afterwards to the email or however you get those out. But my name is Patrick Ely, E-A-L-Y. I'm here, as Rob mentioned, I've been, appointed, elected, whatever, to the vice president's position of the new organization that we're forming. I'm here to present some interesting observations from the last meeting, as well as moving forward some new considerations that I don't think we've heard from yet. The outline we're going to go through is a presentation of some ethical concerns that arose from the last meeting, particularly to the ramifications of the vacation rent ordinance as it currently resides, and then talk about some legal issues, possible Fourth Amendment violations, inverse condemnation, continuous nonconforming use, summary, and some stuff at the end. So the biggest thing to take away from this talk, I also kind of alluded to it in the last go-around, is called legislative intent. What is the intent of the drafters of our laws and our ordinances? What is in their head? What are they thinking when they actually put the pen to the paper? And that's where I was reviewing the minutes from the 2 hour from last time, as well as the deal from back in February. I was looking at what was being said, and I was particularly concerned. Okay, so we have a member of the Vacation Rental Ordinance Committee, and I know she has a chance to rebut, but Ms. Dezel Peterson was appointed to that position on April 19th, 2022 by this board. Later in May, the council went ahead and affirmed it. And on March 8th meeting, she repeated a story about a homeowner who was surrounded on three sides by vacation rentals. Two sides. Well, there's one across the street too. To say that she could go into all sorts of examples of things that have happened at those particular vacation rentals. Upon questioning, Ms. Dezel conceded that the planning committee had failed to approve the
Patrick,
permits.
I am going to interrupt you here and push the button. There's nothing personal about this. So if you have names and we're going to go through by names, you and I are going to have a problem. It was a member of the committee. Understand what I'm trying to tell you? It's not Dessel, it's a member of the committee.
That's what we're getting at.
Thank you.
Yep.
That's why I want to leave it. There's no finger pointing. Don't point it at me. Don't point it at Dessel. This nothing personal about this particular issue. This ordinance is business.
Yes.
Thank you.
Okay, so the problem is the presentations that were given, but the questions were about legislative intent. What was provided was personal testimony. And the issue is that it's impossible to distinguish based upon the pronouns that were used, the we and the our, where were those personal opinions and what is the legislative intent and body of the actual committee. It's hard to remain impartial when you're deviating from just the straight facts. When you're a public official, that's what you have to stick to. And the problem is it's impossible now to distinguish between the legislative intent of the committee based upon those representations made by a committee member, or what were the actual facts and the considerations that were given by the committee while they were drafting the ordinance. Go back and look at the sound bits. And that's where we have kind of a code of conduct issue with Meade County. In the execution of official county business, a member shall not put him or herself in a position where his or her personal interests conflict with his or her duties and responsibilities. Members shall disclose any personal relationships to the governing body in the instance where there could be an appearance of a conflict of interest. That's where we're at here, and I won't play the soundbite here, but the quote was, "He never would have bought in our neighborhood if he had known he was surrounded on three sides by vacation home rentals." I can go into all sorts of examples of things that have happened at those vacation home rentals. We're talking about a person who was addressing as a spokesperson for the Vacation Home Rental Committee who is now deviated into a specific instance. We have a conflict here that's presenting itself. And the board can do with it what they want with that. But this is first observation we made. Now I want to move into some legal considerations. There's, the legal counsel opened up the last meeting by talking about there was it's not a takings and there's not really much that homeowners can do about it. What we're looking at here is several different theories. One of them is a Fourth Amendment violation. The Fourth Amendment guarantees protections against unreasonable search and seizure. Quote, "The permission to search that the property owner provides as a condition of obtaining a permit does not make a warrant to its search a consensual one." That's Calvi v. Town of North Alba, It's over in New York. What we actually have here under section I, or is it J? Maybe it's J. Is that upon the third year of operation to include a site visit by the planning staff. Site visit by the planning staff, you're allowing the government to go onto the property without any sort of approval, permission. They just spawn and they appear there at year 3. It's a property issue. But moving into the guts of the problem, we have inverse condemnation, which is called a takings in common law. It acts like eminent domain, but something is bought by a private owner instead. So eminent domain, you build a freeway, you got to buy the land, you build a road for public good, whatever it is. Inverse condemnation is the opposite, where a homeowner brings an action. This is what we're actually doing right now in Hideaway Hills. I'm the legal strategist over there on that whole mess. So there's 2 basis points for the inverse condemnation that was not previously addressed. It's something that deprives the owner of economic value, and it's also something that fails to promote substantial government interests. Either one of those 2 pillars can support an inverse condemnation, which then raises the question, what is the substantial government interest here? There's also another thing I didn't have time to go into. I was up till 3 o'clock in the morning putting this together, but the contracts clause of the U.S. Constitution has been interpreted to mean that contracts themselves are property. Valid contracts are property, whether the obligator or a private individual, municipality, or state of the United States. That's Lynch v. United States, something you learn in law school, 1934, kind of a fun one there. So the contracts would be the contracts to rent that have already been signed to Airbnb, VRBO, pick up their booking website. Those are commitments. A lot of times the people have already made a 50% down payment. Taking away those contracts is another way of getting out of taking that's been supporting various case laws. So you can't talk about inverse condemnation without talking about the Penn Central test. That is 3 different pillars: economic impact, there's some kind of economic impact being discussed, interference with investment-backed expectations, and characters of the government action. Once again, that legislative intent rings very clearly here. Inverse condemnation, so the owners that have bought vacation rentals with the intent of renting them as short-term rentals and made investments in those, that is who we have here. So the loss of an expectation of interest may be predictable for a takings claim. That's Crow, New Jersey, P. Ship, and Pennington. Or the intent of investment creates a taking, whereby an owner who invested in a golf course and uptook significant costs in capital investments, but was then unable to continue economically after plan and zoning altered his plat. It's Wilson County Regional Planning v. Hamilton Bank, 1985. When you purchase something with the intent to use it as a short-term rental and you then do not allow that person to continue with that initial intent, a takings has occurred. There's also, I love this one, the Calvi test. This is a very recent case. In fact, most all these are. Purchase property that has been used for the very purpose as a short-term rental, which is what we have. This county instituted regulations that undermine the ability of the owner to use the property in that way, and therefore the short-term rental law implicated a protected property interest. Calvi v. Town of North Balga, again, New York, 2021. So inverse condemnations under Calvi, the burden of the short-term rental regulations will force owners to sell its properties and thus a type of takings. That's Weisenberg v. Town Board of Shelters Island, whereby the takings occurs when the person has no economical way to continue with the property and they have no choice but to sell. That's 100% takings by case law. Plaintiffs could not have expected the ordinance's interference with short-term rentals, which pushed them to the brink of losing their homes because they purchased those homes for the commercial interest that they were looking at short-term rentals. Now, something else that the people here, anyone on this board's heard of this before, but, South Dakota Codified Law 11-226, whereby any lawful use, lot, or occupancy of land or premise existing at the time of the adoption of the zoning ordinance may be continued, even though the use, lot, or occupation does not conform to the provisions of the ordinance. This is the grandfather clause. So, again, I'm not a lawyer. I want to make that very clear here. I have no legal training. I'm not tendering anyone any type of legal advice in this situation. I'm a litigation consultant. I tell lawyers what to do and how to make their arguments. This particular ordinance dates back, by way of what Ms. Brittany described at the last meeting, has its origins from May of 2012. The 1 acre provision came in 2016. Those homeowners that were, have been actively, continuously pursuing this use of the property from 2016 onward, might want to talk to some counsel about that and see if they have a claim in there. It's just an interesting point we kind of found was going through these. So the ordinance stands or fails based upon legislative intent. Inverse condemnation can be defeated by showing that the regulations actually do uphold the government's interest. And South Dakota Codified Law 11.2.13, for the purpose of promoting health, safety, and the general welfare of the county, the board may adopt a zoning ordinance to regulate, use of buildings, structures, land for trade, However, the same chapter of law indicates several valid arguments that constitute what this general welfare is. I mean, we all know what health is. We all know what safety is. This general welfare, what's that? It's kind of mushy. However, I want to state that while there's several of those descriptions listed in that chapter and statute, absolutely none of those have been heard here. None of them. Instead, we have a representative of the committee implying that maybe the issue was that for a particular neighborhood. That's not something that represents a legitimate government interest per Katie and Giuliani, again, New York 2000. By the way, New York case law actually is often copied in South Dakota. We love New York for that reason, New York and Arizona. So a summary, legislative intent is a critical element to review of all ordinances to ensure it serves a legitimate government interest. The short-term rental ordinances can raise a government interest per South Dakota Codified Law 11.2. However, none of those arguments have been raised here before this commission in any of these three meetings. I watched both of the previous videos last night. Legislative intent raised by a member of the committee seems to be questioning, is to limit the intrusion of that use within her own personal neighborhood. Multiple high courts have found that a takings does occur when owners buy property with the intent to capitalize them as short-term rentals, and then they cannot. It has been found that a takings occurs when a business or owner must then sell a house because the regulations make it uneconomical to continue in business. My business, we have purchased several of these properties for that very intent. And contracts are property. And while the case law tends to be a little scattered on this, it's possible that South Dakota could rule a due process violation occurs when an ordinance interferes in those contracts and the fulfillment and the ability to fulfill those contracts that are outstanding. So, and finally, the county could be opening itself up to Fourth Amendment violations within the current draft. Finally, one thing to finish on is short-term rentals owners in Hawaii recently, October 26, 2022, made national news for defeating the Honolulu ordinances that made their operations illegal. And it's been there's quite a bit of news out there on that on several of the major news networks. And as this is a new industry, there are unfortunately no U.S. Supreme Court opinions directly on this matter specifically. So what we have to do is we have to look back at the other theories and structures and constructs, such as the Penn Station, the structure, and those sorts of things. But yeah, that's what we have. I wanted to say was, as the vice president of the newly formed organization association, what we wanted to do was come up with our own ordinance and submit it to you in about 30 days and offer it as something in parallel to the current draft. Then maybe you could either adopt ours or maybe take ideas from it and put it into the currently pending piece of legislation. Otherwise, I foresee these meetings going on for many months as we have not even bit but a couple of hot button topics. There's many of them to go through. Legal being just one of them. So they want to have a lot of background in. But I do believe that we can offer something more constructive to start with if we have about 30 days to put it together. So that's all.
Thank you, Patrick. Can you give me the organization? I didn't write it down when Robert said it, and I didn't write it down, I think, from yours, but I didn't catch it in yours. Go ahead. The association, what is the name of it?
Funny, we're still looking on names. Rob, do we have to get a name figured out?
It's going to be South Dakota Short-Term Rentals Association is what we're voting on in a few days.
Yeah, we're going to meet on Tuesday,
Okay.
so we'll meet every Tuesday for the next couple months to get everything built and such. But the South Dakota, what he said,
Thank you.
Short-Term Rental Owners and Management Association or something. We're fine with it.
Thank you.
Yeah.
I just didn't have that down here, and I do try to take notes, so.
right.
Thank you.
I
Any
have-
questions for
yes.
Patrick? Go ahead.
I have you started with the site visits in the third year, search and seizures. I guess I'm wondering if someone signs the paperwork that says they're applying for a vacation home rental in Pennington County, and that's understood when they apply for that, aren't they granting that permission to come for that site visit on the third year?
They are, but they aren't. They could also object to it and say it raises a Fourth Amendment issue. The fact they gave permission, this is what the case law it was about relevant to that. So I'll send the PowerPoint out later. It's showing that they do have, their permit was contingent upon them waiving a constitutional right. And of course, you can't do that. You can't sign yourself into slavery. Same principle. So they could revoke that at any time.
And then a question on the purchase with intent to rent.
Yeah.
That it's a taking. Perhaps the individual that's buying the vacation home rental should understand what local ordinances say first.
Well, the problem is when the ordinance changes. You know, was the ordinance, was it readily understandable? Was it able to be anticipated at the time? So if you do change the ordinance in some massive collateral way, that then makes the intended use now impossible. However, the owner had been operating away pursuant to the grandfather clause. Now you're into a situation where, oh, you're trying to shut them down. Well, one, they have the grandfather clause on their side, but two, perhaps it wasn't, apparently obvious, like they make a dramatic change to the ordinance, that was going to affect their business.
I had another question, but now I don't remember what it was. Oh, I know. On your ordinance that you're going to provide generally to local governments, will you have people that aren't owners of vacation home rentals or managers of vacation home rentals?
Yeah, we definitely intend to open it up, and anybody that wants to contribute to it would be able to. What has happened here is, maybe the committee that formed the current, ordinance draft was too restricted in scope. Like I said, I went through a few of the issues that are created. I mean, it's got a lot of holes in it. They didn't have enough consideration, and we have something that's very, how to dare say it, maybe immature to be presented at this level. So we'd like an opportunity to present it to draft something up from our perspective with our knowledge as either a counter or as a supplement to what you're currently reviewing.
Okay, thank you.
Yeah.
Any other questions for Patrick? Thank you. And I appreciate you keeping it in time, Patrick. Anybody else that was going to do a speaker request form or speak? Read them. I'll address some people and then introduce yourself just
Rita
for the
Chapman.
record. Thank you.
Is this ordinance going to replace the existing one or just be incorporated together? I was kind of confused on that.
This
is it
is a
replacing-
rewrite of the entire
So-
ordinance
so you'll-
to include both the special use permit and the conditional use permit.
So it's not replacing, it's melding together.
I don't understand. Yeah, replacing would be better than melting together.
So you're taking out the current vacation home rental ordinance and replacing it with this one?
Correct.
Okay. Because I'm not going to be at the April 10th meeting, and I want to be able to, I wasn't prepared to go piece by piece about
Okay.
what pieces of the ordinance that are in the draft right now, because I wasn't sure that it was replacing or being incorporated together. So now that I know it's replacing, that gives me a place to start for input. Keep in mind too, with short-term rentals, like a motel, hotel, anything, resort, anything like that, once you've built it, it's always that. A short-term rental is a transient, malleable thing. Just because it's a short-term rental now, it doesn't mean it's going to be a short-term rental in 5 years. So it is something that moves around as circumstances change and things like that. That's the nice thing about vacation home rentals or short-term rentals. They blend back into the community. I sold a house in Hill City that was a short-term rental when we bought it. Then when we sold it, it became a single-family dwelling again. Transitioned right back into the community. Also, with short-term rentals, they're not always bought with that in mind. Sometimes, like in Silver City, they are inherited. I have managed short-term rentals all over Silver City in the 27 years I've been there for 14 days or less that are privately owned by other people. And those are constantly changing. They're constantly changing as financial or familial circumstances change. So someone will inherit a cabin, ask me to rent it out for 14 days for a few years, then they're using it more often, or they sell it to someone who doesn't do it. So it's a constantly changing thing. And so I just thought I'd let you know that sometimes they're inherited. People want to keep a home, not just in Silver City, but other places. They inherit a house with acreage, and they plan on using it as their permanent home later on. But they want to use it in the interim, as a vacation home rental to help pay for the taxes and stuff so they can keep it in their family. That does happen a lot in the Black Hills. So anyway, with that in mind, I'll leave it. Thank you.
I've got
Any questions?
questions for Rita? I've got one, if you don't mind.
Okay.
I guess I use the word fluid. In other words, what you're saying is the actual use from as residential is somewhat fluid
Yeah, it's still
during this process.
residential use of a residential home, but whether it's, a lot of times, people will find out that the owners use it in addition to guests that quote, don't own the place. So,
But it would have a direct relationship to the ownership, whether it becomes fluid or changes.
yes, yep.
Okay. I just wanted to make sure that's what I was understanding you were saying.
Yeah, some they sell, they move, they change, but also the owners will use it, then they let other people use it to get the money, it's very fluid on
Even
who's
under
using
the
it.
same owner sometime, you're saying? Okay. That's,
Oh, yes,
okay.
I've had, in Silver City, I've had people approach me, could you please rent my place out for 14 days or less? You take care of it, you know what you're doing, you manage it. And then 3 years later, the parents aren't coming out as often, the kids are coming out more often, don't use it, don't rent it out anymore. So it's very fluid.
That helped me. So it's not only based on change of ownership. It's based upon the existing ownership may change their mind
Yes.
and make the
Yes,
situation fluid.
yes.
Okay.
Yeah, as they
Thank you.
age or kids age, that kind of thing. So, thank you.
Anyone else? Please introduce yourself for the record.
I'm Byron Altman, resident of Pennington County. And I'm going to say some things I've said before relative to business, which has been brought up here. And that is, I've been around large acquisitions in business. So I am aware that the first rule is let the buyer beware. If you're going to invest a heavy investment, you ought to have a business plan in front of you that's going to make it work. Now, it's not fair for the county to come in after the fact and put rules on that are going to put you out of business. That's right. But in my neighborhood, if I can use the pronoun my, both rental applications were denied on the basis of compliance, not on rules that were brought in after the fact. So let's keep that in perspective. And I recognize you, Planning Commission Board, and Board of Commissioners as the representatives for all of the rest of us residents who are not here to present an agenda. You've got to represent us all, vacation home rentals and the neighborhoods that they're invading.
Thank you. Questions? Thank you. Well, I'm going to go ahead and make a repeat announcement then. This goes on after tonight. The next time it'll be listed on the Planning Commission, which has put these special meetings together. It will be on the agenda April 10th. And the items, there are a number of items that planning commissioners, we have items from the membership in our own agenda each meeting that have already surfaced in regards to what citizens have brought forward from these meetings. There's more than one. And there's a number that are going to be added. I have no doubts. There's commissioners that have other items on their mind that need rewording, that need amendment, that need to be reviewed additional. So it's not going to be a slam dunk process. And I wanted you to understand that before you leave. But this really concludes it. Unless, Jess, do you have anything to say? I know you've been on Zoom. Are you still with us?
I'm still here. No, I don't have anything. Thank you, Charlie.
Thank you.
Charlie,
All right.
there's a hand up in the back of the room.
Yes. Yes. Okay. I just got corrected already. Go ahead. I have to correct it. It's going to be the April 24th meeting because we cannot meet the publication guideline necessary
Oh, okay.
for the April 10th meeting. So the commissioners can write that down as well. I apologize. I tried to do my research and came up with the 10th, but I didn't do very well, did I? Yes, ma'am. Would you introduce yourself, just for the record?
Andrea Steele. And the current ordinance that you guys are amending, was that written in 2017?
Wow. Visual ones, 12, 14. Hard to say. That would be difficult to answer. It's in the ballpark of that time, only because, yeah, I'm not sure on that. I was going to reply and say it's close. I'm trying to go by from the first one to the second one, the revision, and now this is the third review of the vacation home rental.
I'm surprised the date isn't on it somewhere. So that, like amended, revised, and then the date.
That's because we had revised them as you go along. In other words, we could have a meeting that somebody shows that we have wording wrong, a clerical error. You could have a change come up, and we publish all those. It may have had other revisions as well during those years. It isn't just a 1-2 thing. In other words, this isn't the third time it's been looked at. I think we've done some other revisions to it before along the way.
Very minor ones.
But minor, yes.
At the March 8 meeting, you stated that we would have as many meetings as we needed to for this.
Mhm.
And then tonight, you said that this is the last meeting. So technically, the truth was there's only 3.
No, this is the last special meeting. We can have, as long as you want to go on with it and testify, and the board is going to review it. This is the last special meeting. No,
What
you're
does
going
that
to
mean?
control the other meetings by your attendance and your,
I don't understand. If this,
I don't have anybody, okay, I'll just point out to Andrew, we don't have any additional speaker request forms. You even raised your hand to speak. This is a special meeting for you folks to give testimony. Not to review the ordinance, not for the commission to make any recommendations on changes. This is for you. This is the third and the final meeting of that. From there, it will be published again for review by the planning commission. So this is not the last meeting.
If I can clarify, the planning commission can talk about it for 6 months, but our planning meetings are second and fourth Tuesday of the month, starting at 9 o'clock. So we can continue on, but at those meetings, we would be able to take action. We're not taking action at this meeting.
the public can't come to those then.
Sure.
You can email, you can come in person, yes.
Oh, okay. I just don't know how you guys structure this. And then who votes and when is I guess you kind of answered that because you don't know how many meetings there's going to be, but is it just you 7 people that vote?
We vote to make a recommendation to the Board of Commissioners and send that document on with our recommendations to them, and then they take up their review process. Yes, and they are the ones that either vote to activate the ordinance or not.
On the website, how come it's so hard to find these meetings? Because I went and I Googled the county, and then I went to public meetings, and it's not listed. So then I had to call, and then the lady said I had to go through 4 steps to find where this meeting was posted.
That one I can't answer. I'm going to have Brittany.
On the front page of our planning department page.
It's not under the website, public posting meetings.
It's on the front page of our planning commission page, our planning page. It's been there for a year.
That's all I had.
Okay. Thank you, Andre. Questions for Andre? No. Thank you. Well, I guess we further elaborated. This is going to go on, and we can't continue to hold special meetings forever and publish and whatnot. It's time to sit down and start acting or revising or throwing out or changing whatever we've got to do to begin to actuate the process. And that's what happens next. We've changed, it's not the 10th now. For all of you that I wrote down the 10th from what I said. And I really had researched that, but apparently it didn't meet the deadline for the publications. And we do have certain state requirements as well as our own county requirements. And it will be published, but it will also be on the site itself. Anything else members want to add? Thank you for attending. I'll add that. Is there a motion to adjourn?
So moved.
Is it second? Excuse me.
What?
Robert? Go right ahead.
Robert Heckel again. Just to clarify, so we're moving on to the next meeting, but what we brought up with working with planning and zoning, how are we going to know if you're willing to do that, or what is our next step to deal with that? Are we supposed to reach out to you, planning and zoning, on other days?
I would reach out to
This
us.
is
I'm not even sure what you're
Because
proposing.
what you're saying is we're going to have multiple meetings. We have.
That's the work ahead of you. You've got to do something in writing. You can't.
We are.
Okay.
We have a
You're
lot of stuff
answering
going
your
on.
own question. That's what you need to do next to get involved in these meetings as well as attendance, just like you have here, and you guys have been very good about attending. We need the same thing from you at the Planning Commission meetings. Those are open to the public. That's not a closed session.
Okay.
They always have been open.
So if we wanted to present our ideas with that would be the next step is
That
then?
has to come through the planning department because they are the ones that issue the agenda to
So
us.
how do we get that all out within a 2-minute period of time frame?
2 minutes?
Or whatever our time frame is. So if we come to the next planning meeting, we come up here to present it, how are we going to get all that information to you and go through it step by step by step? That's going to get drawn out too. Because right now
I started out by saying, you got to get some of this in writing. We're not going to put on unlimited time out there for you to present these things. We don't have an unlimited time to do them.
I understand you don't have unlimited time. I see your
Let
frustration.
me finish, please.
Okay.
It needs to be in writing through the planning process. That planning process, then we issue an agenda that's published.
Correct.
And we go from that. And if you have in writing, I don't care if the writing's 200 pages long, Robert. I'm going to read it. That's where we start.
Sounds good.
Thank you.
Thank you.
Mr. Chair,
Yes.
you might clarify that during our normal meetings, we don't have a 3-minute time limit on people speaking.
That is, at this time, we don't have a 3-minute time limit. If we had people backed up, we'd have to look at reviewing it that. I don't want to leave that open that couldn't happen. That is done by the membership of the Planning Commission to decide to limit the amount of testimony. But
Brittany Molitor, Planning Director. So if they wanted to submit comments based on the ordinance, if they want to submit a whole separate ordinance, they have to do it. There's a statutory requirement under 718A. They would have to do it, is that if they want to submit a completely separate ordinance amendment.
okay.
718A.
All right, I didn't realize that we were talking about a whole separate ordinance. I thought we were talking about her.
Sounds like they were wanting to
See, that's what I'm saying. We don't have anything writing. I can quickly get confused on that, let alone the date. But anyway, to go on, this will be on our agenda, April 24th. And that will be the next step in the process for the ordinance. Now, have we got a motion to adjourn already?
So move.
Second. Moved and second to adjourn the special meeting of the Planning Commission in regards to the vacation home rental ordinance. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried.